Hello folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. So again today we will be continuing with the winding up of the companies. Right, we have a very few lectures on this topic remaining. And the provisions over here will be referred to with the Companies Act 1956. So the basic topic under consideration for today's lecture would be the defunct companies. Right, but this is not the first lecture that we are having or we are holding on the defunct company topic. So anyone of you who have missed the previous lecture, please go back and refer to that video before continuing with this lecture, right? Because in the previous videos, we have already started with the concept of the defunct company and discussed what is the defunct company and also the procedure of the registrar, right? So unless and until you are very clear with that, this class will not be of a great help for you. And for the others who are continuing with all the lectures in the serial order, for them let us continue with the provisions of the defunct companies, right? So basically what have we done in the previous lecture is we have understood the meaning of the defunct company, right? The company that has stopped its functioning, they have become defunctional, right? And then we have also seen the procedure that the registrar will follow before striking off the name, right? We have seen that yes, the registrar needs to send a letter of inquiry, which is just a formal letter, a formal communication. If no communication is received within 1 month, then the registrar sends a registered letter within the next 14 days. Again, if no communication is received within 1 month, or if there is a negative confirmation, then the registrar publishes a notice in the official gazette, right? And this notice is also hand delivered delivered by post to the company, right? And what is the content of the notice? It says that if you do not reply in the next 3 months, then we would strike off the name of the company from the register of the company, right? Because we consider that the company is not functioning. And again, if after 3 months they do not receive any information, any communication from the company, then the registrar would strike off the name of the company, right? And then again publish it into the official gazette that the name of the company has been struck off. The company does not exist anymore, right? So that is the topic that we have discussed in detail in the previous lecture of what happens, how does it happen, what is the rationale behind and everything. So if you already know that topic, you can continue ahead. If you don't, go back, refer to it, sink it in, and then we continue, right? So now we start with the provisions that we will be covering in today's lecture. The procedures followed by the registrar for confirmation that no liquidator is acting in case of winding up. Yes. Now we take up an entirely different scenario, right? The previous kind of companies that we have dealt with, the defunct company that we're talking about, over there we discussed about the company that has stopped functioning, right? There was a company that was into its operations, into its whatever is the operation, manufacturing, providing of services, any kind of thing, right? But lately the registrar has stopped hearing anything about the company. The products are not coming in the market, the services are not being provided, right? And then the registrar has some reason to feel that yes, the company has become non-functional. It has become a defunct company. It is not carrying on any of its provision, but still the name exists in the registrar of the companies, right? So these kinds of companies, if there is something to the next level, that means if they are not even filing their statutory reports, not taking away the statutory meetings and everything, then the registrar should actually file a petition in the court, right? We have referred to this when we were doing the compulsory winding up, initial 2-3 classes, right? If you remember. So we know that yes, if something is wrong to that extent, if it is that massive and that pervasive, then the registrar has no option but to file a petition to the High Court, right? And the court then gets into the matter, understands it, and analyzes it, and then orders winding up, right? And then we continue the procedure of compulsory winding up, right? But in that scenario, we did not reach that level. That means the company has been some regular with its statutory reports, statutory meeting and everything, but the operation is not being conducted. That means the objective of the company for which it was formulated, the objective that is given in their article of association, those objectives are not being met. That is why it is a defunct company. Clear with that? So we saw that what is the procedure that the registrar follows to strike off the name of those defunct company. That means to dissolve those companies without winding up, right? So there are two situations. If the registrar thinks it needs to be wound up, it goes for the compulsory winding up by filing a petition in the High Court. Otherwise, it can also strike off the name and dissolve the company without winding up if it thinks that yes, it is the call of the situation, right? So those are two scenarios we have already seen. We have seen in detail what is the compulsory winding up, and we have also seen how does the registrar strike off the name of such companies. Now over here what we are seeing in this slide, in the tab that is in front of you, the procedure followed by the registrar for confirmation that no liquidator is acting in case of winding up. What do you understand over here? Over here we are not talking about those companies in general, right? Over here we are talking about something that is to the next level again. What do I mean by next level? That means the company, right, was not performing maybe, right, did not file their statutory meeting, no statutory reports being filed, no meeting being conducted, or there are some other reason because of which someone, either the registrar or the creditor, the contributory, the members of the company, anybody, right, anybody has filed a petition with the court, and the court's order of compulsory winding up is in process. Or the other situation is the company has gone into voluntary winding up either through the members or through the creditors, or they started with the voluntary winding up but now they are being supervised by the court. So any of the three situations where they are succumbed to the winding up of the companies, right? So when the company is winding up, when the company was winding up, and we see that the winding up procedure is not being conducted, now again there is one catch to think. When will there be a situation when the winding up procedure is not being conducted? Can that be in any situation where there is an official liquidator? No, official liquidator will complete the winding up somehow. If it is not being conducted any further, if there is a deadlock, if there is end to winding up and the liquidator knows that there is no way out, then they'll go for dissolution directly, right? But in case of official liquidator, having a halt on the procedure of winding up for a long time, no response, nothing, that is a rare situation, right? Because High Court is standing behind. But in case of voluntary winding up, that is a situation that can take place. The company has themselves appointed a liquidator and none of them are performing. The liquidator initiated the winding up proceeding but is not taking it further, and it has been long. You remember, if they take it for more than 1 year, then you have to submit the statement of accounts and stuff. Over here, they are not taking forward, they are not coming ahead with any statement of accounts or anything. It is just that the liquidator has stopped. He has no reason to justify that yes, I have done this during the year. That is the situation where the registrar thinks, okay, they have become defunctional again. Even the registrar has become defunctional. So now they will strike off the name of the company in this scenario as well. Right? Now do you understand what we are talking about in this case? And how is this case, this scenario different from what we have discussed in the previous lecture? Right? So we'll see what are the grounds based on which the registrar would strike off the name of the company which is being wound up, which is in the process of winding up. So again in this case, the registrar would send a letter of inquiry initially, right, to the company that okay, we think that you are not performing, and requires a response, and then sends a registered letter, and then again requires the response and goes with the same procedure. Will it do so? Do you think these tabs are correct on the screen? Do you think it will again send the letter of inquiry over there? There is no need of letter of inquiry, because when the company is being wound up, the registrar already knows that they are not functioning, they are not taking forward their operations. So this letter of inquiry and registered letter is of no use. So we again delete these tabs. Right? The only reason why I showed those tabs to you is that you get a link that okay, in the previous situation, this was the procedure the liquidator followed. Right? If you go back to the previous situation, the letter of inquiry, registered letter, publish a notice in official gazette and strike off the name. This was the procedure we followed. Remember, this is not the same procedure we will follow in case of winding up. Right? And I'll give you the rationale behind why not. So if we come to winding up, I have removed those two tabs, the two tabs that I created, letter of inquiry and send the registered letter. We remove them because that is not needed. Because understand the purpose. Why do we send the letter of inquiry? Because the registrar is not sure whether or not the company has stopped functioning, whether or not it has become a defunct company. Right? Before being assured of the same thing, can the registrar strike off the name? No. So first the registrar tries to understand whether or not you're functioning. So it has sent those two letters. But in this situation where the liquidator is already appointed and the company is already under the process of winding up, that means they are not carrying on the business. So any inquiry, any correspondence required from the company is not relevant over here. Right? So what do we do directly is we publish in the official gazette. What does it publish in the official gazette? The same thing that it used to publish in the case of the defunct company. That this is a notice to the company that okay, you are under winding up, right? But I think the winding up procedures are not being conducted. So if you are into winding up, the liquidator is there, you should be active. So within 3 months, please respond back to me. What is the procedure that you have been conducting? Are you still functioning? Or is the liquidator still taking ahead the process of winding up? If yes, well and good. If no, I would strike off the name directly. That means I consider that you have already been wound up. If you're not going to the court for dissolution, I will be striking off the name. Right? That is what the registrar wants to communicate. And this notice will also be delivered to the company at its registered office via the registered post. Right? So that the registrar who is sitting over there, the liquidator who is sitting over there will be aware if it's not referring to the official gazette. Right? So we are skipping the first two processes and going directly to the notice. We are directly issuing it in the official gazette. Either you reply to us in 3 months because we know you're not functioning, or else we strike off the name. Right? And then you dissolve the company. That is where if no notice is received, if no communication is received from the company within that period of 3 months that was mentioned in the notice that was published in the official gazette, then the registrar would straight away strike off the name of the company from the register of the members. And then what will it do is it will issue another notice in the official gazette that yes, we have done so. Right? It would publish a notice in the official gazette. And on such publication, the company would stand dissolved. That is what we assume. The day it is published, from that day, it will stand dissolved. So no other case, no proceedings, nothing is carried forward. The company stands dead from that specific date. Right? Now, going back to the topic that we were considering, that is, this is the situation where the company is under the process of winding up. Right? So what had gone wrong? What was the reason why the registrar had to take these steps? Right? It is basically registrar would take these steps if he reasonably believes, right, that no liquidator is acting. Either there is a vacancy in the office of liquidator, or the liquidator is present but is not acting, or the company has not appointed any liquidator yet. It has passed the resolution of winding up but has not appointed any liquidator, or the company has appointed, and if it is a case of creditors voluntary winding up, they have not come up with the confirmation of who should be the liquidator. Whatever be the situation, liquidator is not there, he is not working, or the office has become vacant. But the crux is the registrar thinks that the liquidator is not acting. And number two, okay, maybe it is not considering the fact that okay, the liquidator may be working, whatever be the situation, but what I consider is, what the registrar considers is that maybe the winding up procedures have come to an end. The company has been successfully wound up, but again 1 year has lapsed, or maybe the next year or the third year has lapsed, an entire year has lapsed, and within 3 months, you know that the liquidator had to call the meeting and distribute the statement of affairs, what it had done, the entire accounts of the dealings, of the procedures followed, right? The liquidator does not do it for the period of consecutive 6 months. 3 months was the time given to it, but it's 6 months that has lapsed, but the liquidator did not continue with that procedure. So the registrar may follow these procedures to strike off the name. That it's being late and we should now dissolve the company. Right? And so for doing that, the registrar undertakes these two procedures, that is the publication in the official gazette and the dissolution of the company. Clear with that? So this was the second situation where the registrar goes ahead to strike off the name of the company. So we have covered both the situations. where the company was a defunct company and where the company has started winding up, but the winding up procedure was at halt, right? Now we see what are the consequences of this striking of the name. What will happen when the registrar strikes off the name of the company from the register of the companies? So that is one thing that you already know, right? Once the registrar strikes off the name of the company from the register of the company stands dissolved, right? But do you think this is the correct procedure? That okay, one fine day the registrar thinks the company is not working, the company did not reply, and the registrar strikes off the name. The company has assets, the company has liabilities, right? The company has people involved, the employees, a lot of things. How do you dissolve the company when the company is still existing, when the assets are still there, right? When tangible, intangible assets, when everything is still existing, and you dissolve the company, that means now they cannot carry forward any dealing. Once the company is dissolved, they cannot sell off their assets in the name of the company, that yeah, these assets were in the name of XYZ Limited and I sell it off to Mr. Y. No, you cannot do that. Why? Because the company is dissolved, the company is not in existence. So any document that you prepare in the name of the company now will not be valid. You understand that? So we say that okay, if the registrar strikes off the name, the company stands dissolved. But again, there can be issues. If there is no issue, that means it was a small company, it did not have a lot of assets, it did not have liabilities, nobody turned up, nothing happened, they're still lying vacant, no issues. Let it be. Because they're not working, they're not interested, they have left it vacant. They have abandoned it. If they have abandoned it, we have no issues with that. Let it be abandoned. No liabilities, no creditors are coming up, nobody is filing a petition, right? And let the assets also be there. The registrar is not concerned with those things, right? But again, this kind of dissolution is not the permanent dissolution, right? That means if the court at any point of time wants to wind up the company now, to sell off those assets and pay off the liability, the court can do that, right? That means you struck off the name of the company, you issued a notice in the official gazette, and then one of the creditors, they turned up that I have a lot of due from the company. How could you just dissolve the company without paying my dues? So the creditor files a petition to the court, and the court says, okay, is that the situation? I will appoint my official liquidator, he will go to the company, and then he will sell off all the assets and pay you your debt. And then the court has the authority to order winding up, even though the company had been dissolved with the procedure of the registrar, right? Because initially we had seen that the order of dissolution will only be passed by the court. The court is the sole body that has the authority to dissolve a company. So although we consider that yes, if the registrar has struck off the name, right, we consider it to be similar to dissolution, but that is not actual dissolution of the company, right? So when the court is ordering this winding up, he need not turn away the order of dissolution by the registrar. That is still into procedure, right? The court does not have to undergo any formality to first nullify that order of dissolution and then go away with winding up. No, that is not needed. That dissolution was a temporary dissolution, or was the dissolution in the name of the company. The asset or the underlying facts behind the company are still there, that can still be dealt with, right? It's only the name that has been struck off, that it is no more a company as per the register of the company, right? So court, without referring to the order of dissolution by the registrar, can still order winding up if he thinks fit, right? And that is why the liabilities of the managerial person and the members are not affected. If there is any director, manager, managerial people who were in the company, their liabilities will continue even after such dissolution. That is the scene, right, where the court can order winding up. If their responsibilities had come to an end, nobody would turn up to the liquidator. Liquidator would come, hey, I want to wind up the company, this is the procedure I want to follow, send me the statement of affair and stuff. Nobody would turn up, right? It's not my responsibility. The company has been dissolved, please go back home. Understanding? That is why it says that the liabilities of the managerial people, the board, the management and everything, that will still continue. So that if required, we can take away this procedure of winding up. Right? So you understand the consequence of striking of the name? Yes. Now the last thing that we see is the mode of sending the letter of or notice to the company. It's seen, right? It sends the letter of inquiry, it sends the registered letter, it sends the notice after the official gazette, after it publishing it into the official gazette and stuff. Now, how does the company send them? We have seen, right? This is also not a very lenient topic to skip, right? Because again, you need to understand something very clearly. We have already seen that okay, whenever the notice is to be sent, notice is sent at the registered office via the registered post. Finish. Right? But now if you look into the matter, if you go behind the fact, then what has happened? The company over here is considered to be defunctional. Do you think you will find anybody in the registered office? If the registrar thinks that the company is defunctional, if it is a defunct company, then it will also be necessary for the registrar to think that there is a high probability that nobody would be found in the registered office. So even if we send that letter of inquiry, even if we send that notice, nobody would turn up. Nobody would turn up because they don't know that the letter of inquiry has come. They don't know that the registered letter has come or the notice has come to them. They are at their home. So that is why the registrar needs to make sure that the people, the management, the directors of the company, they receive it. They know that yes, we are inquiring about it, otherwise we will strike off the name. So for that purpose, if no office has been registered, right, understand, if it is a registered office over there, the registrar still has to the authority to be done with its responsibility by sending it to the registered office. But okay, there is no director, nobody over there, but maybe the peon is over there, he'll communicate it to the director, right? That can still be considered. Otherwise it can still consider that okay, if it has reasonable ground that nobody would see it over there, he may send it to the director at their home. Like in the procedures, for example, if the company does not have any registered office, not at all, no office has been registered, then in that case he would send the notice or the letter in the care of some directors, the manager, the secretary, or any other responsible officer of the company, right, to keep them informed and so that the procedures are taken forward well. Now suppose if the registrar does not have the addresses of those people, it was not specified in any documents of the company, it was not registered with the registrar, then what does it do? There is one thing that has to be there at the initiation of the company, that is the memorandum and the article of the company. That has to be registered, otherwise there was no company incorporated, right? So at least those memorandums and articles are there with the company, and in that memorandum there is the detail about the subscribers of the memorandum, the people who signed the memorandum, right? So now he would send that letter of inquiry or that notice to those subscribers of memorandum. Okay, you incorporated the company, take a look, this is the notice, I'm sending it to you, please revert back. If you think there are some other people in the company who is supposed to revert back to that notice, please refer the document to those people and get their name and address registered with the registrar, otherwise we are not able to communicate, and that is the reason why we are communicating directly with you, right? So first you send it to the registered office, but if you do not have any registered office, you can send it to the directors, officers, manager, anybody from the company whom you think it is reasonable. And if you do not have the address of those people as well, you send it to the subscribers of memorandum. That is one thing that has to be there with the registrar, otherwise the company would not have been incorporated, right? So that is the entire function of the defunct company, entire procedure that we had to follow in the case of the defunct company, right? Are you okay with it? So I consider that the entire topic is clear. If there is any query, any doubt that you have, please use the comment box, and if everything is clear, hit the like button over there, right? So our next lecture is going to be a very short lecture, like somewhere around 12 to 15 minutes maximum, because over there we'll be discussing about the restoration of the name of the company. We would have discussed it in this lecture as well, but since we do not have a lot of time, if we include more 15 minutes lecture over here, it would exceed half an hour video, right? So that would be a little cumbersome task for you to grab it also. So what we do is we break the video over here, right? We break the lecture over here, and we'll continue with the restoration of the name of the company in the next lecture for you, right? So be done with the defunct company completely, and then move on to the restoration of the company, right? So please stay tuned for that lecture. Until then, this is Abhinay Gupta signing off. Thank you and bye bye.